Welcome to the Cuban Adjustment Act, overview of relief and common issues, sponsored by the ABA Commission on Immigration. If you are seeking CLE credit, you must attend the entire program. Partial credit is not available. Please click on all participation verification alerts during the program to confirm your attendance. Immediately after the program ends, a link to complete the certification process will appear. Please complete the evaluation and the CLE affidavit, providing your bar information as requested. Once the completed form is submitted and your attendance is verified, your certificates will be emailed to you. Moderating the program today is Emily McCabe. Emily McCabe is a senior staff attorney for the Family Group Legal Orientation Program in the American Bar Association's Commission on Immigration. Emily, whenever you're ready, you may proceed with the program.
Thank you so much, Osman. It is my pleasure to welcome you today to the Cuban Adjustment Act Overview of Relief and Common Issues. Thank you all for joining us today. Our panelists today, they are true experts in the Cuban Adjustment Act and in the immigration field at large. First, we have Jasmine Coca, who is the Director of Immigration Services for Catholic Charities of Southern Nevada in Las Vegas. She primarily represents individuals in removal proceedings before the Las Vegas Immigration Court and other immigration courts within the United States. And we are also joined today by Mark Prada, who is the co-founder of Prada Orizar Dominguez PLLC, a law firm that focuses on resolving complex immigration issues such as defending individuals in removal proceedings and representing immigrants in federal litigation. His practice has included arguing cases before the Supreme Court and the 11th Circuit. And for more information on our wonderful experts, please see their full speaker biographies in the written materials. And Jasmine, please take it away.
Thank you. Okay. The Cuban Adjustment, which we call the CAA, was created as an independent pathway to permanent residence outside of consular processing when adjustment of status was barred for Western Hemisphere nationals. It was designed to serve as a refugee law before asylum existed as a form of relief. Originally, parole was the mechanism to give refuge to persecuted populations. Conditional entry was created by Congress in 1965 to allow Eastern Hemisphere refugees a pathway to permanent residence. The Cuban Adjustment Act was modeled on that program. And so I'd like to add also that with the Cuban Adjustment Act, when the Castro regime took over, the United States was very anti-communist. At that time, the Cuban citizens who fled Cuba after that regime took over, they became allies of the United States. And with the creation of the Cuban Adjustment Act in 1965, it was to sort of destabilize the government in Cuba. And at that time, Cubans had to physically reside in the United States for 2 years. Now they only have to physically reside for 1 year. We'll get to that later, but it's just very interesting how it's evolved over the years. Next slide, please, Emily. So, Cuban Adjustment Act of 1966, and as amended 1976. There is a USCI Adjudicators Field Manual that has a specific chapter on Cuban adjustment or adjustment of status, chapter 23.11. USCIS Policy Memo, VAWA amendments to the Cuban Adjustment Act, continued eligibility for abused spouses and children. That was in 2016. The USCIS Policy Memo updated guidance for Cuban Adjustment Act cases on August 13th, 2019. And the CAA was never incorporated into the INA, and the implementing regulations were never promulgated. So Mark can talk more about the litigation aspect of that, because there's the citing of Perez v. USCIS. It's an 11th Circuit case in 2014, but that is correct. Even though the Cuban Adjustment Act it's Section 1 Cuban Adjustment Act is usually what we file applications under. However, it is subject to the requirements under Section 245 of the Immigration and Nationality Act. It is a discretionary application, which means that it is in the category of family-based petitions, trafficking adjustment cases, anything related to crime adjustment cases. However, in the USCIS Adjudicators Field Manual, they are supposed to If there are any issues with a Cuban adjustment case, they are supposed to list the positive factors as well as the negative factors. So your client may look like they do meet all the requirements of Cuban adjustment, but let's say that they have an in absentia order or they have some sort of removal order. USCIS can consider that removal order, even though technically, if they're arriving alien and they're paroled, USCIS can still, approve those Cuban adjustment applications. However, in my experience with USCIS, they have listed those factors or that as a negative factor, and I have found that sometimes they don't list the positive factors. So they're supposed to, balance both. So pay attention to that if you have a case where there may be some issues in your client's case and you want to make sure, bring it up to the officer that they should consider all factors. Okay, a Cuban adjustment, sorry, you can go to the next slide. Cuban adjustment eligibility. The principal applicant must be a native or citizen of Cuba, have been inspected and either admitted or paroled into the United States, must be last entry matter of REVA. This case came out in 1967. Mark may discuss that a little bit more if we have time later. We were talking about the MPP program and how that case may apply. Have a total of 1 year of physical presence in the United States and be admissible to the United States pursuant to Section INA or to INA Section 212 little a. So as long as the applicant can demonstrate that they were born in Cuba or have citizenship in Cuba, they should be able to establish that for purposes of applying for Cuban adjustment. As I referenced earlier, they have to show physical presence, which is really not that difficult to do. You can do that through rental agreements, bills, documents relative to removal proceedings if they have that, or order of supervision through DHS. It's not difficult to establish, and then be admissible. So if your client does have crimes, DUIs do not usually make someone inadmissible. Battery, domestic violence may be considered in a case as a crime involving moral turpitude, but still you can make these arguments and your client can still be successful in receiving relief. Next slide, please. Thanks.
Hey
Cuban
everyone. So,
adjustment. Oh, oh, sorry, that's Mark's. Thanks.
hi everyone. So, normally this is easy. Your client is a Cuban national. They have a birth certificate from Cuba or a passport, and you qualify them, right? But um, separate from what I'm going to talk about, there's derivatives, so-called derivatives, where spouses or children of a Cuban national who are not themselves Cuban nationals can apply. But now, what I'm going to speak to you about is the equivalent of a derivative naturalization or acquisition of Cuban citizenship. So this is going to be a lot of fun. So when Cubans left their home country, a lot of them migrated to South America, for example, Ecuador or Venezuela, and just lived there. And they have children born there, right? So when you think about the child of a Cuban who migrated to a third country, um, there is an argument that the children are Cuban as well. So this has recently come up in cases of Venezuelans in Miami, at least from my experience, that are children of Cuban nationals who were born in Venezuela. So in 2017, USCIS changed its policy on this. So it rescinded a case called Matter of Vasquez. And Matter of Vasquez was from many years ago. And so to explain what it holds, I need to explain how the process works. So if you're a Cuban national in a third country and your child is born in that country, you can go to a Cuban consular post or embassy and register your child with the Cuban government there, and they'll give you a document noting that. I forget the exact name of it, but the consulates of Cuba in the third country where the child is born would give you the document acknowledging the Cuban citizenship of the child, or at least the registration. So under Matter of Vasquez, that document was sufficient to show that your client who was born, let's say in Venezuela, was also a national of Cuba, and then they could use that in a just status, and that happened for many years. So in 2017, USCIS rescinded Matter of Vasquez, and they basically someone in the Library of Congress did an investigation after they received the cable from the Cuban Ministry of Foreign Affairs, disputing that. And it goes into this heavy discussion of how somebody derives or acquires national citizenship through birth abroad. Um, but in the memo, it recognizes that there was an amendment to the Cuban Constitution pending at the moment they issued this memo. Um, so what we've discovered is that that memo is moot, right? Because it relies on Cuban law that doesn't exist anymore. And like, so I'll get to that in a moment of what the actual rule is, right? So um, there's a later policy alert in August 2019. So our firm, we brought suit on a case of Montes Valdivia versus the district director in Miami, challenging the memo on the merits, but also with a retroactivity argument, because that memo came out while my client's case was pending, and they had the registration from the Cuban consulate in Venezuela that I was describing before. Um, and the lawsuit was stayed and held in abeyance for almost a year or more. As during that process, what we had the client do is that they took that document um, and they had a third person file it with the civil registry in Cuba, and they were issued a birth certificate from the civil registry. USCIS will not accept that birth certificate. So then they went to the consular section of Cuba in Washington, D.C., and the persons there sent the first birth certificate to be legalized with the Ministry of Exterior, if I recall correctly. So then a second government agency issued a legalized birth certificate, right? So we were arguing that does the trick. And then with that birth certificate, the consular office of Cuba in Washington, D.C., obtained another order, a decree from the Ministry of Interior in Cuba, which declared the person as a citizen of Cuba. And USCIS still wouldn't accept that. So then the client used that document to obtain an actual Cuban passport, and then finally they granted the residence for this person and his family. So if you encounter these situations, you need to go through a very long process to obtain these whole series of documents so that your client has the passport, so that you can apply with USCIS and have this issue resolved easily. But we still think they're wrong. And actually, there was another case that we brought with the intent to sue, because we found 3 Cuban attorneys, 2 in Cuba and 1 here in Miami, to write expert declarations explaining the legal process in Cuba. So under the new laws in Cuba that were enacted after the 2017 USCIS memo, they state that the proof of citizenship comes from the Ministry of Interior. The Ministry of Interior will issue a document that they title a decree. That is your proof of citizenship, not even the passport. But USCIS is insisting on the passport, and with their guidance, even in the 2019 guidance, which I still never understood, they're requesting documents that don't even exist anymore. That these are old documents that from decades ago that were used to establish citizenship. So this is all ripe for litigation eventually, because I mean, one, the memo is already moot, and like they even predicted that it would be moot in the memo itself. So um, I'll leave it at that because this is a very lengthy discussion, and it could be a seminar all on its own. So just be aware of that, that there are options. I would just suggest that, tell your client to do what they need to do. They need to go to Washington, D.C., and speak with the officials over there from Cuba to get all the paperwork done to somehow get the passport, which could easily take more than a year. Next slide, please. So I mentioned before the non-Cuban spouses and children of Cuban nationals. They can obtain status under the Cuban Adjustment Act. So this is very different from the marriage petitions, because you must show that the spouse or children are residing with the Cuban national at all times. Okay, so under a marriage-based adjustment, as long as you prove the marriage was valid at inception, even if the couple separates, they can still obtain the permanent residence at the end of the day. That does not work in the Cuban Adjustment Act. So we're citing Gonzalez versus McNary, where the Cuban national had passed away, and the court held that the spouse and stepchildren were no longer residing with the national who passed away, so they weren't eligible to adjust status. So this is a stricter rule than normal. Um, However, the 11th Circuit did take on another case, Silva Hernandez, which was a pretty interesting outcome. So the Cuban Adjustment Act gives you a retroactive approval date of a certain number of months, right? And in this case, Ms. Silva sued for that date to be recognized, and USCIS refused to recognize it because they claim that, well, you were married uh, after the date that you're claiming as your adjustment date, and the 11th Circuit said that that was wrong. The statute's plain that you get this retroactive date. It's not dependent upon the date of marriage. So this is very important because, say for whatever reason, the client gets in trouble and they become deportable, let's say for a criminal offense, and you need to make sure they have the 7 years of continuous residence. You need to make sure you have the right rollback or retroactive date to preserve their eligibility under the stop time rule. And also, there's an old regional commissioner case, matter of Million, where it states that once the main Cuban has adjusted status, if they marry later, the spouses who are of that marriage can continue to adjust. So I guess at that time, the service was arguing that the relationship, the spousal relationship, had to exist before the principal Cuban obtained permanent residence. Uh, which leads to another important point. In the 90s, there was a law called NACARA, which helped Nicaraguans and Cubans and other groups of people. So there was a group of Cubans who were not eligible for Cuban adjustment because they entered unlawfully. There was no parole, and they obtained the residence through NACARA. So there's a link to an unpublished case from the AAO, exactly that situation, where the Cuban national obtained residence under a different law, and his spouse, who was non-Cuban, was able to benefit from the Cuban Adjustment Act, even though the principal Cuban did not use the Cuban Adjustment Act. So there's USCIS often finds ways to limit relief and derivation. So these are important cases that have defeated those attempts from the agency. Next slide, please.
Thank you, and we'll pass it over to Jasmine.
Okay, thank you. Okay, so when you're applying under the Cuban Adjustment, they're filing the I-485 application, which is the adjustment of status application used in family-based cases and other types of relief being sought. An I-765 application for employment authorization, and then of course the G28 notice of representation or notice of entry of appearance if they're represented by counsel. Before, just a fun fact, there used to be additional forms that we would have to fill out, like a health and statistical data form and some other form. Luckily, immigration has eliminated that form, so there's just not a lot of documents you have to submit with the adjustment application. I do request a police clearance letter from the police department or from the city in which the applicant has resided for the last 3 years. During COVID, that was more difficult to get. So actually, I've gotten away from that a little bit, but you should request that and submit that with the application. An affidavit of support to overcome public charge and admissibility under INA Section 212A4 is not required. That is true. They're applying on their own. So we don't have to submit even the waiver affidavit. I forgot the formal name of that. We don't have to submit that. So this form is also, you are allowed to apply, or the applicant is allowed to apply for a fee waiver in the event they do not have the $1,225 to file the application. They are subject to that. I do tell my clients when they're applying that it may take a month to 2 months to get a decision on the fee waiver from USCIS, and it's not guaranteed if they are pursuing a fee waiver, but USCIS will not issue a receipt for the I-485 and the I-765 unless a fee waiver has been approved by USCIS. Next slide, please. Applicants submit their applications with either USCIS, the United States Citizenship and Immigration Service, or the Executive Office for Immigration Review, which are the immigration courts. The distinction is explained in matter of Martinez-Montalvo, which is a BIA case from 2009 that changed how we adjudicate Cuban applications before the immigration court or even USCIS. So at this moment in time, if you have a client who is paroled, most likely they're going to be in the category of an arriving alien under matter of Martinez-Montalvo. And if they're in immigration proceedings, immigration court does not have jurisdiction to adjudicate the Cuban adjustment application. I mean, there are some exceptions, but largely no. So in that situation, if the Cuban client is paroled or is an arriving alien, you can request termination or dismissal, as they call it now, before the immigration court so that they can proceed in filing their application with USCIS. I mean, I have had clients who are still in removal proceedings who have been able to adjust with USCIS while still being in removal proceedings. So that may not necessarily bar them. USCIS used to be more strict about that and would want us to dismiss the cases, but that doesn't always happen. So they still should be eligible. However, and then it's up to how counsel wants to handle these cases. If they are not an arriving alien and if they do not have the parole document, ideally you should file your Cuban adjustment application with the Texas Service Center. Like for us, the Texas Service Center receives the fees for certain applications for adjustment, cancellation, and removal. I don't know what other application, waivers. We submit the fee with the instruction sheet, and then they issue the receipt, and then they will issue a biometrics appointment. We want to keep that jurisdiction, ideally with the immigration court, or at least we did. Mark may have a different perspective about that as of late. But technically, if they're not arriving aliens, then immigration court would have jurisdiction to adjudicate the Cuban adjustment. So a lot of the clients, when they have gone outside of Catholic Charities and their counsel, have insisted on applying for adjustment of status through a notario or on their own. They usually file with USCIS, and then they may get a receipt, they may get employment authorization. However, they will get a letter eventually that reads USCIS is going to administratively close that case because they're in removal proceedings. One thing that I have to explain to the applicants is, okay, yes, you're in removal proceedings, but just us dismissing your case, if we're able to do it, and I haven't been successful in doing that if they don't have the parole and they don't have anything else pending, is that USCIS will not continue to adjudicate the application if they don't have the requirements under Cuban adjustment. So best to keep it before the immigration court. Next slide, please. Okay, so if they do have a pending application for adjustment of status under the Cuban Adjustment Act, I usually tell my clients it takes them between 6 months and 18 months to either have an interview or get a decision on the application. But in the interim, they are eligible to receive employment authorization. Now, for those who practice immigration law on a regular basis, it usually takes many months, if not be a year, to get employment authorization for your client. So I do give them that time frame, but they are eligible for it. A lot of the clients think that because they got the employment authorization, or even the fact that USCIS accepted their application, particularly those who are not arriving aliens and not paroled, that immigration is going to approve the application. So I have to say that there are additional steps and arguments that may need to be made, but they are entitled to employment authorization. If the Cuban adjustment application is approved, then it's great. They have lawful permanent residence. They receive the card for the 10-year period. They have the ability to travel outside of the United States. Many Cubans want to return to Cuba. As of late, many of my clients do not, but that's usually the first thing they want to do is travel to Cuba. and it won't jeopardize their status, as it indicates in the slide, unlike an asylee or a refugee. They are able to naturalize faster than an ordinary person, not an ordinary person, but maybe someone applying under another form of relief, because the card does go back to from the date of entry. So I believe I think no more than 18 months. So let's say if the person was really late in applying for Cuban adjustment, they didn't do it after the 1 year and 1 day. I've had clients do it years later, but they were eligible, and for whatever reason they didn't before. I think it goes back 18 months. Mark can correct me if I'm wrong, but I think that's how that is. So, and of course, I always encourage the clients to, as soon as they're able, to apply for citizenship. Emily, is this the next? Am I on the next slide, number 11?
We're going to pass it over
Okay.
to Mark, actually. Thank you, Jasmine.
Okay, thank you.
Yeah, I'm just waiting for the slide update here. Oh, okay. So removal cases. Prosecutorial discretion. These memos, as some of you may already know, the Fifth Circuit yesterday left an injunction in place against the Mayorkas memo from last fall. So the Doyle memo is based on the Mayorkas memo. So at least here in Miami, we've caught word that the Doyle memo is not considered as being in place anymore because of the injunction out of the Texas District Court. But you could still request prosecutorial discretion either way. You're just not relying on the priority system that the Doyle memo references. So most likely, I think dismissal is what the most likely option you will get from the government to agree to. Administrative closure, I use that when the clients are arriving aliens and we've already filed their adjustment application with USCIS. So I'll use that evidence to request the immigration court to do administrative closure rather than asking DHS, because the request for prosecutorial discretion can take many months to get a response. A status docket was a procedure put in place by some courts during the time period that administrative closure was not available. So the short explanation on that is that Attorney General Sessions issued a decision in matter of Castro Tomb forbidding administrative closure. But since then, Attorney General Garland has brought it back, so now you can request it directly from the immigration court. So at least in my experience, the status docket's not really being used very much here in Miami, at least, since administrative closure is an option. But given our insane backlog in Miami, at least, I like making motions directly to the judge, because requesting it from DHS can take a long time, except for the dismissals, because the judge cannot dismiss on their own in most cases. And aside from that, if your client's not an arriving alien, the immigration court has the jurisdiction to hear the adjustment application. So many Cubans want their attorneys to apply for adjustment in addition to asylum and immigration court. All you need to do is look at the TRAC statistics on asylum grants, and you could see that they're very low. So having an alternative relief is a huge deal for your clients. Next slide, please. The public benefits. In the 1980s, there was a law. I think it was called the Cuban Haitian Entrant Act, or something similar, where these nationalities, if they were paroled into the country, they could qualify for certain public benefits. There's a link to a fact sheet from the Department of Health and Human Services, but I can tell you with my experience here in South Florida, the Department of Children and Families is responsible for these benefits. So basically, this law, if it applies to you, you're treated as a refugee for the purpose of public benefits. But since the end of wet foot, dry foot, DHS has had very inconsistent practice on documenting paroles or not, which has caused confusion with the public benefit agencies. So the best thing to do, I think, is to refer to the fact sheet when you advise clients on what to do when they're seeking public benefits.
Mark, can I say something, please?
Sure.
Can you hear me? Okay. Um, you may want to also look to see if your state has a state refugee agency. That may be helpful because maybe some of the agencies, like such as ours here at Catholic Charities of Southern Nevada, we do have a program. That's why I have so many Cuban clients, is because we resettle Cubans here. So you may want to start there. Just go online and look that up as well and see if they can provide guidance. And perhaps your clients can even enroll in the refugee program so that they have a case manager that can also assist them with access to public benefits. Thanks.
So I alluded to this issue previously. So there was a policy from the 90s called wet foot, dry foot, which was ended in 2017. So just to give some historical narrative, very shortly after Castro took over Cuba, the governments of Cuba and the United States disestablished their diplomatic ties, and there were no removals to Cuba, starting since the 1950s or 60s when this started. And there were a series of freedom flights and other programs where Cubans were being brought to the U.S. and they were all being paroled into the United States. And as Jasmine noted earlier, parole was the original method to bring refugees into the United States until the 1980s when the asylum laws were passed, the Refugee Act of 1980. Um, so at that time, no one was being removed to Cuba at all. Until the mid 1980s, there was a beginning of diplomatic talks with the United States and Cuba and attempts to create some sort of removal program after the Mariel boat lift of 1980. And eventually, in mid 1990s, the wet foot, dry foot was the compromise to that. So the idea was that if a Cuban had touched land, they were not going to be returned to Cuba. Whereas if you were interdicted at sea by the Coast Guard, let's say, you would be taken back to Guantanamo and for a period of time a base in Panama where you could request a refugee application there, but essentially people were being returned to Cuba. So the wet foot dry foot policy, we think of it as a beneficial position, but it was actually a restriction of the prior practices because before that policy was implemented, even Cubans interdicted at sea were brought to the United States and paroled, and then after a year they would apply for residence. So when that program was ended in 2017, it wasn't the end of a parole program, right? So it wasn't a command that you shall not parole Cubans anymore. What it was is that it it basically took away the exemption from expedited removal from Cubans. And there is a notice in the Federal Register explaining all this. So when expedited removal was enacted in the IRIRA in 1996, there was an exception for nationals of Western Hemisphere nations that don't have diplomatic ties with the United States. So that seems like it was written specifically for Cubans, but because that's the only group of people it applied to. But now what's the law is that Cubans are subject to expedited removal, meaning that if they approach the border, they're supposed to be detained. They're supposed to be given an administrative removal order without seeing a judge. They'd have to claim a fear to speak to an asylum officer and make their case to an asylum officer to see if they're allowed to apply for asylum with a judge. And that's what basically was supposed to start happening, that all the Cubans were supposed to be subjected to expedited removal beginning January 2017. However, in practice, the majority were not being subjected to expedited removal. They were being released with notices to appear for a full removal proceeding or to report to an ICE officer who would continue the case. So in practice, nothing changed, right? For the people who were not subjected to expedited removal, legally nothing changed, right? Because the practice was they were still catching and releasing Cubans, if you want to use that terminology. Um, but then what happened on the ground is they stopped giving paroles to document the release. Because parole, going back to the 1950s in the Supreme Court cases, is just a release from custody for people who are not entitled to be admitted, right? So this has always been the understanding of parole. But now you'll receive clients who have all sorts of different documents. The famous release on recognizance. There's an I-385, which is basically a short form piece of paper that's half the size of a normal sheet of paper with biographic info and other types of documents, right? So um, DHS is doing this because they don't want these people to adjust status. Because right now, as a policy matter, DHS is in the position that they would welcome the repeal of the Cuban Adjustment Act. It's come out in many papers, and they don't want to allow. They don't want a large group of Cubans arriving at the border irregularly and then obtaining residence. Considering the policy aims of closing the border and keeping it protected, this this issue of Cuban adjustment causes internal confusion, or not confusion, but more like stress, right? Because you want to protect the border, but then you have a group of people who are entitled to residence if they're here for a year. So this whole practice of not paroling them on paper is meant to close off that door to relief. If you can go to the next slide. So I've practiced habeas cases, and Jennings was an important decision for habeas cases, and many people regard it as a bad decision. And yes, for people who are fighting mandatory detention and prolonged detention, it is a bad decision. But I think there's a silver lining to it, because essentially I'm relying on Jennings for the argument that there is no way to explain the release of someone who arrives at the border except for parole. And I mean that in the sense that you're seeking an admission into the United States and you are released while your application for admission remains pending, or whether during the time period your admissibility is still being determined, right? Because when you receive the NTAs and it says you're inadmissible and you're sent to immigration court, all the immigration judge is doing is determining whether you're admissible or not. So your application for admission is still ongoing. You haven't been admitted. You're still excludable, if you want to use the prior framework. So Section 235 of the Act governs admission in the sense that A1 defines who is an applicant for admission. So that's a statutory term, and that includes essentially everyone who has not been admitted, right? And so USCIS, DHS uses this distinction of arriving aliens and not arriving aliens. I think there's a strong argument that that whole distinction is unlawful, because IRIRA was designed to repeal that, because that distinction of the arriving alien comes from exclusion proceedings. And if you were to look at the say the 94 version of Section 235, it defines people who are subject to exclusion as the ones who arrive at ports of entry, which is the current regulatory definition of arriving aliens. So in a sense, this framework from DHS of dividing up arriving aliens with those who are not was a resistance of IRIRA, because IRIRA, according to Jennings, everyone's mandatory detention if you have not been admitted. So, for example, taking it to an extreme, if you have a client who entered unlawfully and has been here for 10 years and is eligible for cancellation, applying Jennings to their case, that person's mandatory detention as well. They're not supposed to have bond hearings with the immigration court. They're not subject to release under Section 236A. So this distinction between 235 and 236 is critical to this argument because 236A permits what's called conditional parole as an alternative to paying a bond. And in Jennings, they stated that if you're detained as an applicant for admission under 235, whether it's an expedited removal or for the full proceedings under 235B2, a humanitarian parole under 212 is the only way to release the person. And this is in Jennings. So then the argument we're making is that 236 doesn't apply to these persons at all. And if you look at the release on recognizance, the first line at the very top of the order says that pursuant to 236A, you're being released on your recognizance, right? So the orders of recognizance are actually conditional paroles under the statutory framework. And that's important distinction because there's BIA case law which has been affirmed by multiple circuits that having conditional parole does not qualify you for adjustment of status. So the argument is that we're not trying to argue that the conditional parole qualifies you. We're trying to say that that's unlawful and that you look at substance over form, and what actually really happened here is that these people were released on humanitarian parole. There's a small handful of immigration judges who have agreed with this argument. They are in the minority. I've filed these briefs in dozens of cases, at least 100 by now, with different judges around the country in different circuits. Most are very quiet and they're not ruling. And a very small handful have written decisions denying it for different reasons. I've really only come across two that I think are well reasoned, even though I disagree with them. But and I say well reasoned in the sense that they engaged with the argument. Um, so what I'm noticing is that the can is getting kicked down the road, so to say, because there are appeals at the Board of Immigration Appeals pending right now. So there, like I said, there's a handful of judges in Miami, well, less than a handful, but a couple who are granting adjustment applications to Cubans with the releases on recognizance on the idea that these could only be paroles, and DHS appeals every one of those cases. So there's a whole slew of cases uh, on appeal to the board, and eventually the board is going to pick one of those cases to make the precedent on this decision. Um, and unfortunately, I don't have much faith in the Board of Immigration Appeals. I think they try to resist circuit precedent and try to make distinctions to further the administration's goals rather than trying to reach the correct legal outcome. That's my pessimistic view. Of course, um, everything is eventually appealable to the circuit courts, and I think this will one day get to that point. Um, but separate from Jennings, the MPP case is very interesting, and actually, the injunction from yesterday regarding the priority memos discusses this point as well of what it means for detention to be mandatory. So in the Texas versus Biden decision from the Fifth Circuit last year in the MPP case, they specifically held buried deep in this 100-page decision that 236A conditional parole is not an option at all for an applicant for admission. Essentially, the argument I've been making under Jennings. And there's a footnote, I want to say footnote 17 or so, where the Fifth Circuit said, this is a very important point because this determines whether a person can apply for adjustment of status or not. Right? So it went up to the Supreme Court. They ruled on it, I think, just last week. They did not decide that issue on the parole of whether 236A or 212 or some other form of law enforcement discretion that's not statutory exists to permit releases for people who are technically subject to mandatory detention. What I will say is that in his concurrence, Justice Kavanaugh said there's only three options: detain, return the person to the contiguous territory, or 212D5 parole. Alito, Thomas, and Gorsuch in dissent said the same thing, that only parole is available for release. Of course, that's only four justices. I think this is an issue that will return to the court maybe very soon, because the MPP case is on remand, and this is an issue that I think is still open for resolution again. So we need to keep an eye on what's going on, not just in the MPP case, but also the priority memos cases, because what the Fifth Circuit said yesterday there is that these people are mandatory detention under different provisions, but it's all basically the detention framework, and they were deciding that there is no extra statutory, let's say, latent discretion to release people, that the statutes mean what they say. So I'm sure that will be going to the Supreme Court very soon, at least on a motion for a stay of the ruling from the district court, which enjoined the memo. So stay tuned is the short answer. If you can go to the next slide. So I believe we already spoke about this a bit, about how the immigration courts are responding. Interestingly, at least in Miami, we're seeing mixed results from USCIS. But let me discuss a case called Rebello that my firm we filed last September. So we took groups of arriving aliens with denials from USCIS where they wouldn't recognize the parole. And long story short, eventually we settled the case, so to speak, where USCIS published a notice, and we voluntarily dismissed at that point. So when we brought the case, it wasn't just arriving aliens. We had a few other people that were present without admission, and the government's response was to put them in immigration court, which basically killed jurisdiction in the district court. So if people ask, why is USCIS recognizing this for arriving aliens but no one else? It's because for USCIS to make the case non-justiciable for arriving aliens. So they'd rather just concede than allow a district judge to rule on this. So I applaud them. That was a very good strategic move on their part, because I think the district court was hinting that it was going to agree with us on at least with arriving aliens. So right now there's this notice there, and the way it's written is for people with denials, that they can file 290Bs or new adjustment applications with the copy of the notice if you're an arriving alien. And they try to narrow it temporally to certain groups of people, but this is not the limits of what USCIS is doing, because basically the agency knows we're going to come back with more lawsuits if they don't apply this broadly to other arriving aliens. We have a FOIA request pending with DHS for basically anything discussing this topic, or whatever internal guidance or memos are before CIS or CBP or ICE on this. We'll probably file a FOIA suit sometime soon on that, just so we can understand how DHS is interpreting this issue. Now, I can say that I've seen emails from deportation officers stating that Jennings versus Rodriguez only applies to arriving aliens, which doesn't make any sense, but it really seemed very copy and paste. So I do suspect that some sort of guidance is going around. So if you have clients like this that are arriving aliens, just file your adjustment with USCIS, regardless if there's a prior denial or not. My understanding is that an ISO from CIS will communicate with a deportation officer to obtain a correction of the release paperwork, so at least that group of people can proceed and have their adjustments decided on its merits of discretion. So what about everyone else, right? So the non-arriving aliens who are in immigration court need to proceed through the immigration court system. I think many of the cases will just be delayed down the road. You need to prepare asylum applications regardless because the BIA should rule sometime in the next few years on this, and then we'll see the next part of the saga. If you can go to the next slide, please. Okay, so there are a few other things going on. So the last group of people we've been talking about are under 235B2 of the Act, which is the non-expedited removal cases. But what about the B1 cases, the ones that are expedited removed, right? Matter of MS is an Attorney General decision from Jeff Sessions, which essentially is implementing the Supreme Court's decision in Jennings with a start date, with a delayed implementation. So I don't know how an administrative agency believes that it can put a implementation date on a Supreme Court decision. I think that is completely unlawful. And then there's some immigration judges talking about the a case of Padilla versus ICE, I think in the Western District of Washington, over in the Ninth Circuit, which enjoined matter of MS on constitutional grounds. Very important because the District Court and the Ninth Circuit never disagreed with the statutory reading in matter of MS or Jennings. So if IJs are resisting arguments based on matter of MS, the response I've been making is that it's not matter of MS, it's Jennings. And when the Supreme Court interprets a statute, that's what it means since the day it was enacted. And this whole attempt from the Attorney General to delay the implementation of Jennings is unlawful. And I guess that's an argument for a circuit court at the end of the day. But I'm seeing three categories of persons within the expedited removal proceedings. So what should be an obvious matter of MS parole is you pass the credible fear and they release you with the NTA. Jennings says it as well. The only way to release these people is with a parole. So you should be able to argue that they have been paroled. I think this is a practice that started last year because I'm only seeing it now. There are people released from custody at the border with no NTAs. They file a 589 with USCIS, and eventually USCIS dismisses the asylum application, stating we don't have jurisdiction because your credible fear interview is pending. So that's an odd situation, and if you can obtain a FOIA on these people, you'll find an expedited removal order. You'll find notations from ICE stating that the person was released pending an interview with the APSO, the asylum pre-screening officer. So these people were, again, subject to mandatory detention. We have the citation there of the very pinpoint citation explaining that you are supposed to be detained pending your credible fear interview. So these people should have been paroled as a matter of law when they were released. So this is an issue bubbling up. We're filing adjustment applications with USCIS in these cases so that once there are sufficient denials, we're going to try another class action with them. The last group there, this one's very interesting. These are the negative credible fear cases. So there's normally when you have a final order of removal, you're released from custody under an order of supervision. That's section 241 of the Act. But if you ever have somebody with a negative credible fear finding and they're being detained for a prolonged period and they file a habeas petition in the district court, Department of Justice will argue that you cannot obtain habeas under Sidvitis versus Davis because there's a special provision to maintain them in detention under 235 with the citation there. Because under 241, after the removal period has expired, you're in a discretionary detention. That's 241A6. Whereas the 235 that's pinpoint cited here in the slide, that provision says if you fail your credible fear finding, you are shall be detained until removed. So that's actually the only true indefinite detention provision because there's no cutoff date and it's not discretionary. So there's a U.S. Attorney Bulletin. You can find the U.S. Attorney Bulletins online. And there was one about immigration issues published when Jeff Sessions was the Attorney General, where they actually lay out this argument in the bulletin with citations to district court decisions that affirm it. So what I say is what's good for the goose is good for the gander, right? So if they're arguing that these people cannot be released on supervision except for parole when it conveniences the government in habeas cases, well, the rule should be the same when you apply for residence. The meaning of a statute doesn't change because of the context it's applied to, right? So um, that's another group of cases that we're filing adjustments on with the intent to bring a district court action once denials come in. The good thing about all these cases, the pending credible fear or negative credible fear, is that the agency does not have a way to moot out the case by starting removal proceedings because there is no removal proceeding to be started. So then the district court will have jurisdiction throughout the case unless they were to rescind the expedited removal orders. And I find that sort of unlikely. It'll be interesting. So we'll see what happens with the chess game down the road. But so these are the new projects, I guess we can say, of what's going on. Next slide. Okay, so what's happening in Miami? Wow, we have somewhere between 20 and 30 immigration judges, if I recall correctly. And I have hearing notices for 2023 and 2024 in many of my cases. And I think the statistics show that Cubans make up a very large portion of the persons arriving at the border these last few years. And since they're being put in removal proceedings with the DHS aim of making them apply for asylum without allowing Cuban adjustment generally, they are representing a very huge portion of the docket here in Miami. And I think there was something called the dedicated docket that they came up with last year about recent border arrivals that their asylum cases were supposed to be adjudicated within 300 days. Cubans have been exempted from the dedicated docket now, and their cases are just going to linger for years. Um, and basically, it's just a huge waste of resources, right? Because there is a law from Congress meant for these people to just obtain their residence, at least until the day that Cuba becomes a democracy. Because in IRIRA or similar law in that time period, there's a sunset date on the Cuban Adjustment Act. The day that the president certifies that Cuba is a democracy, the Cuban Adjustment Act is immediately repealed. So we're not there. It's still the law. These persons are supposed to have this pathway to legalization for as long as Cuba remains a repressive regime. And this is a essentially the policy, international policy set by Congress. But DHS does not want to accept this because they don't want to allow these paroles on paper. So my short answer is that what DHS is doing is nonsensical. You have basically a shadow population of persons who cannot get their work permits, who can't legalize themselves, and they're not going anywhere. They have not been able to deport anyone to Cuba since 2020, and I think the overwhelming of the population of these people who are arriving will never be deported. So having them live in the shadows without an ability to have jobs and pay taxes, it doesn't benefit anyone. So I guess I turned this into a policy argument. My reflections on Miami is that these cases are clogging the docket and they're not going anywhere, and it all seems really pointless. And I really hope that there's a way that this can all be fixed for them down the road. I'll turn it to
Thank you,
Jasmine.
Mark. And now,
Okay, thank you. So prior to matter of Martinez Montalvo, which the BIA issued in 2009, as I don't know if I explained previously, but second to Miami, because we resettle so many Cubans here, Las Vegas saw a lot of Cuban migrants before the immigration court. But because we had wet foot, dry foot policy, they were 99.9% of them were paroled. So it was a very simple process. And the immigration court back then would administratively close the cases until the respondent accrue their 1 year, 1 day under Cuban adjustment. We would file for Cuban adjustment, then recalendar and terminate proceedings. And that was it. And even once there were interim regulations that came to be in 2006, I think I made my arguments before the court, because interim regulations were that perhaps the immigration court would not have jurisdiction anymore over arriving aliens. However, in making arguments with the court, and I believe the judges at the time, because it's a different group of judges that we have now, had still decided that they had jurisdiction to adjudicate Cuban adjustment cases for arriving aliens, because interim regulations are not permanent regulations. They are provisional regulations. And at the time, too, USCIS here in Las Vegas was not prepared for the number of Cuban respondents who would be seeking adjustment before the office here. So if we were to terminate proceedings, then their cases would automatically go to the Las Vegas office. And I believe our office at that time, it was a much smaller office. So they were not prepared for that. There was discussions about that. But once, and then also there was some Ninth Circuit, in talking about interim regulations, there was Ninth Circuit law in regards to arriving aliens in general, not just Cuban, which indicated that the court would still have jurisdiction to adjudicate arriving alien applications. So next slide, please. So I was talking about matter of Martinez Montalvo. Once that passed, then that was it. Immigration court had in writing that they could no longer adjudicate Cuban adjustment applications if the Cuban respondent / applicant was an arriving alien. So we terminated those cases. We also saw nationwide that Cuban migrants who were being paroled into the United States were no longer being issued notices to appear. So really, there were probably very few Cuban respondents who had cases before the immigration court until the end of the wet foot, dry foot policy. Then we started to see, because there was no consistent policy anymore about how to issue paroles or how to allow Cuban migrants into the United States, then we started to see the notices of the NTAs being issued again, and then Cubans being placed in proceedings. Next slide, please. So I'm kind of ahead of myself, but just to give you statistics about the number of Cuban migrants who've requested assistance through our agency. So we have a Migration and Refugee Services Agency a program here. A lot of my clients I get who are Cuban are referred to me by that program. So because of that, we've seen 727 Cuban migrants have requested assistance with resettlement since January 2022. Only 77 of those 722 have been paroled. So we're beginning to see more Cuban migrants or entrants be paroled if they're in the MPP program, and then they're released and they're getting the paroles. But I don't know, like yesterday, for example, my assistant was talking to me about a husband and wife. The wife is Cuban, the husband is Venezuelan. They came together to, they entered the United States together, but they were separated. The wife has not been placed in removal proceedings. She's Cuban, not paroled. He was detained for a period of time. He was paroled. So now I have to figure out what to do. So it's just with a lot of us who are handling Cuban cases, I mean, I get a lot of questions from practitioners in the community about what to do. We just kind of have to review all of their paperwork, see if there's something in their paperwork that indicates they were paroled, because a parole is not going to be a standard I-94 card anymore. A parole can be a piece of paper, maybe with their photo on it, maybe not. You might actually have the back of the card that reads parole, so you have to locate the first page of the parole. Even in the past, we've seen for EOIR, the change of address, where the respondent has to agree to change their address with EOIR within 5 business days. I've seen where they've been paroled under 8 CFR 212D5. You really need to look for that and see, and it's not consistent. And as Mark indicated earlier in the presentation, besides looking at documents, you may have to determine if the respondent has been paroled, maybe by asking ICE, maybe by asking OPLA, because they may not have been presented with all the paperwork, so maybe in a database. So I've had that situation too. And speaking probably for other practitioners who do handle a lot of Cubans, it's like winning the lottery almost when they are paroled, because we know a parole is a parole. Even if ICE does not believe that it's a full parole, for purposes of Cuban adjustment, in my opinion, it is a parole. So even if they were paroled for 1 day, who cares? It's a parole. So come 1 year and 1 day, you should have them filed for adjustment of status. But as Mark indicated too, you should, if your client, it's not clear if they're an arriving alien, under the memo, under Mark, in February 2022, maybe your client may not be categorized as an arriving alien on the notice to appear. So you may need to make those arguments and talk to your client about how he entered and with whom he spoke when he came in and all that kind of stuff, and then determine what way you want to go. But you still should file asylum applications to preserve the 1 year if you can. Next case, please. Slide. Just thinking cases. Sorry. Well, I'll just say this. With the immigration court here in Las Vegas, you should still continue to file your Cuban adjustment applications if your client is not an arriving alien and not paroled. You should still, brief the issue with the court. This court is very experienced with Cubans. They have not, to my knowledge, at least not with my briefs, have issued decisions on, or issued decisions on whether or not they would adjudicate a Cuban adjustment when they're non-arriving, non-paroled. And I believe it's because the immigration judges, just like probably other courts, they want something in writing. They want either ICE to issue that or the Board of Immigration Appeals or someone, because it just would be easier. So it would be easier for not only the immigration courts, but for CBP, for ICE, for USCIS, for immigration court, and of course for our clients, and for counsel to determine, if a person is eligible for that relief. So, a lot of people with the NTAs, they're not admitting and conceding the allegations and the charges. Even, if their client is not listed as an arriving alien, please continue to do so if that's what you so choose. And I guess it's just like, we have to do whatever we can. Other counsel, even some notarios, I question it, but other counsel have said that they've applied for parole documents by filing I-131s with USCIS just to see if something is going to stick. If something does come out of that, then all of us probably will be doing that. We just are trying to be as creative as we can to be able to help our clients. So thanks.
Thank you so much. And before we turn it over to the Q&A, I just wanted to make a quick plug for pro bono opportunities. Pro bono is a fantastic way to practice your skills for your own benefit as an attorney and as a way to give back to the community, and of course to help vulnerable immigrants who cannot afford attorneys. Please consider taking a case on pro bono, or looking into the pro bono opportunities. You can use the QR code here, or I will post the link in the chat. And now we'll turn it over to Q&A. And we have a lot of really great questions in the Q&A box. So and I just want to remind everyone that you can still be sending in questions through the Q&A box. The first question is, how does the Cuban Adjustment Act apply to MPP? If somebody was placed into MPP but was not paroled into the United States. You can start.
Mark should address that, please.
So there's so many things that could happen factually there, right? One scenario that I'll speak on, which has functioned for us and has led to approvals, there was a judge in California, the detention center there, that had MPP cases, who was terminating proceedings because the NTA didn't designate as arriving alien or not. It's a little more complicated than that, but there was a BIA decision in 2020 overruling those decisions. But what happened to that group of people is that they were brought in through the port of entry for their hearing, and proceedings were terminated, and Mexico wouldn't take them back. So they sat in detention for months and were eventually released from custody. And they were released with the orders of recognizance. So we filed with USCIS, arguing that they're arriving aliens, because the MPP instructions tell you to come in through a port of entry, and that's the only way they would have gotten to where they are. And we noted the case of matter of Riva in one of the earlier slides. It's the last entry that controls. So then we convinced CIS to take jurisdiction, and then what happens with MPP program, like when you get to the port of entry and they bring you in to your hearings, you're paroled into the country for prosecution. So most of these cases have paroles prior to the actual release, and we were able to show that because the TAs were filing I-261s stating that the person had been paroled for the hearing. Now, I don't think this is going to be the case in every MPP case, but we were able to use essentially the MPP instructions and the I-261 to prove the parole, and USCIS approved those cases. So that's one framework. But essentially, if your client is someone who entered with MPP and was released from custody, and that MPP entry was their last entry, they are arriving aliens. Now, to figure out if they've been paroled or not, you might have to do some FOIAs and try to see if there's anything documenting the parole into the country for the hearing. Next question.
Sorry about that, I had myself muted. Does the NTA toll the 1 year for physical presence?
Short answer is no. There's no stop time rule, like for cancellation. But related to that, I had clients who were detained for several months and then released, and they believe that the 1 year presence starts the moment they were released. It's not true. It's from the moment that you're physically in the United States. And there's an old BIA case about aggregating presence, where somebody's here, let's say for 6 months, leaves and comes right back, and then you get another 6 months. The physical presence from those periods of time can be added together, as long as you can demonstrate there was no intention to abandon a residence in the U.S. But for that, just wait the extra 6 months so you don't have to deal with that.
Can I say something? Regarding the NTAs, I mean, I've used them to prove continuous physical presence, just to show that the respondent would have incentive to cooperate with the government and be interested in their case while in the United States because it's an official government document. So I have used it for that reason. And before the February 2022 policy, I would submit the NTA with an adjustment of status case to show if they were an arriving alien, to highlight that the government acknowledges that they were an arriving alien. Because prior to, I don't know, 2021, I was arguing not even necessarily parole, but admission and inspection with USCIS if they were arriving aliens and indicate that they had requested admission and were essentially admitted and inspected, and it was working. And my Cuban clients were issued, their lawful permanent residence cards. And then that changed when the cases were referred to USCIS here in Las Vegas, and then they were just held in abeyance. But that NTA can be very helpful to help establish the physical presence or the fact that your client is an arriving alien, in case for some reason you still don't have the parole document and you want to proceed on the client filing for adjustment of status while they wait for a parole document.
Thank you. And the next question is, are either of you seeing a lot of individuals charged as arriving aliens? And this person says they haven't seen one in recent memory here in Atlanta.
Mark,
Been a long time. So I guess when Title 42 expulsions and MPP began, that was the end of the arriving aliens, at least in large, because there was no way to enter through the port of entry. I mean, there might be some still, I guess the people I spoke about who entered were NPP but were released without being returned to Mexico. Those are arriving aliens. But I haven't really seen any others. As far as I can tell, the ports of entry are still closed under Title 42.
I've seen some individuals be issued NTAs as arriving aliens. We were talking before this webinar started. I've seen some individuals who were released from the MPP program and nothing is marked on their NTAs. Maybe they're charged under Section 212A7, but they're not listed as an arriving alien nor admitted and inspected. I mean, given what Mark was saying about, you can make some arguments that your client is an arriving alien. I think for that's really good because nothing has been marked. And even if it has, I mean, you can still make arguments that someone is an arriving alien versus not an arriving alien. But I've seen that more and more, which is very interesting to me. And as I was telling Emily and Mark, I had a hearing with the Harlingen Immigration Court yesterday on a detained docket. My client's not detained, but they still had her on that docket. And the trial attorney for OPLA indicated that they don't mark those NTAs because they believe that the respondent is an applicant for admission. Because I was wondering what to do in terms of pleading and all that. I wasn't prepared to do it. I was just taking the case. But I feel like there's some arguments when things are not marked and things. So that's something that we can kind of sink our teeth into as well.
And next question is, have you heard of USCIS ever being open to the order of recognizance counting as parole?
Okay, so for the arriving aliens, yes and no, because USCIS is basically the position that they are not questioning what ICE did. So what they do is they reach out to ICE and say, hey, can you fix this paperwork? So they're still taking that position that it's not up to USCIS to second guess what ICE did, right? But those cases, but to view it in a more compressed kind of way, whether USCIS will adjust somebody with a release on recognizance for arriving aliens, yes. For people who are not, I've seen very mixed results. I've seen approvals and then I've seen denials. So it seems like they're still trying to work that out. as long as your client is not in removal proceedings. Okay, they might do it or not.
Here in Las Vegas, uh, the USCIS office before, especially with arriving aliens with no parole, they were just holding the applications in abeyance because they were trying to on their own. So before Mark's efforts and the February 2022 memo, were trying to see how they could resolve the issue and how they could approve the applications for Cuban adjustment for those applicants. So I do want to commend them for that. I didn't receive any denials from the Las Vegas office if the clients did not have the parole. I don't think on their own and on a case by case basis, the officers were not trying to make decisions about the order of release and recognizance constituting a parole or being sufficient for purposes of Cuban adjustment. But there was that. So they were trying to do what they could by themselves. And then when this memo came, then of course, they sent all of the files to ICE here in Las Vegas to get the paroles issued. We're still waiting for paroles, but that's okay. But they will come under this memo, and then we'll be able to complete those cases. But I do want to just say this, if I can add, with the I-2220A, I'm sure everyone who has Cuban clients, everyone is under the misconception, not everyone, but many Cuban applicant or individuals are under the impression that if they have that form, then they can adjust their status. So I always tell them that they should seek legal counsel. If they don't have legal counsel, as their counsel, no, they are not automatically entitled to apply, because I want to prevent them from filing and making a mistake on their own. Because like I said, sometimes people do that aside from me and they'll try to do it on their own. We need to make sure that that is clear about this policy not applying necessarily to those with just an I-220A. Again, if you're making sophisticated legal arguments, that's one thing. But right off the bat, it's like arriving alien parole. I hope I was clear about that. But I seem to give this speech every day to my clients. So
And next question. Would the INAP, the interim notice authorizing parole, be valid for purposes of the CAA?
Oh, I didn't hear that one well.
Sorry. Would the interim notice authorizing parole be valid for purposes of the CAA?
Absolutely.
yes. I mean, that's what we're seeing here in Las Vegas when they issue the parole, especially if you're an arriving alien and you've applied for adjustment of status. It's a paper and it reads just that. It's an interim parole. That's all USCIS needs to complete the processing of the application. Anything that remotely reads parole or in the name, like, just assume that it's a valid parole and try to use it. Even if it's handwritten, just use it. If it's handwritten by a government official, use it and say they were paroled.
Thank you. And next question. If a Cuban has been paroled pursuant to 212D5 and is waiting for the 1 year and 1 day, is it still necessary or prudent to file for asylum?
Mark?
I think there's two schools of thought. As long as there's no other inadmissibility problems and the adjustment is one that you can confidently say should be approved, there's no need to apply for asylum. I guess if you're talking about is it worth the costs of hiring an attorney and all that. The other side to the coin is that everybody is eligible to apply for asylum. You can be a lawful permanent resident and be eligible to file for asylum. I would advise, I would have the discussion with the client where they give informed consent waiving an asylum application before telling them you don't have to, just to be ethical about it.
Hmm. Um, yeah, I mean, I think it comes down to your decision and what the client wants to do. Maybe I may not file an asylum application in that case if, like Mark said, I can determine that that person appears to meet the requirements, prima facie eligible to adjust their status when their 1 year and 1 day comes. We have seen a lot of people like super close to their 1 year, or if they're past their 1 year anyway, by the time they get to me. So if they have the parole, then I just tell them to just proceed in that way. But it depends. And I've also had some clients who were very worried, like they still wanted to apply for asylum even if they had a parole. So, we'll prepare the application for asylum and still file it if that's the case. Um, but I think it just depends on you and the facts of your client's case and what they want to do. Yeah.
And related to the 1 year and 1 day requirement, have you seen any success with Cubans on the dedicated dockets who are pushing back on the 300-day deadline for adjudication so that they can show the 1 year of presence?
There's a judge in Miami, Judge Videla, who's supposed to be retiring. I don't know if he's still there or not, but he was granting continuances to dedicated docket Cubans by ruling that they had been paroled um, based on the release on recognizance paperwork. Um, so I don't, beyond that, I haven't seen anything else.
I haven't either. I haven't had to deal with that issue. I would like to add this. Sometimes when I'm in court and it looks like the person has reached their 1 year and 1 day, um, or they're right before, the judges do ask, because the judges here, they would, they want the clients to be able to adjust their status. And if that option becomes very clear and it is a written policy, then of course they're going to want the client to pursue that relief over asylum based relief. But they will ask me, oh, can they apply for adjustment of status now? What do you think? Is there anything new that we should know about in the court? So, um, but in terms of a dedicated docket, I haven't had that issue. But the judges are interested in the clients, you know, being able to pursue adjustment if they have their 1 year and 1 day.
And next question, um, can we ask ICE to parole the respondents?
Yes, you can ask. Will they grant it?
Right?
I would, I would be very impressed if you can convince them to grant it. Very impressed, because I mean, I think kind of the attitude at DHS is that they hold the keys to whether you can apply for residence or not, and they don't want to give that away.
Yeah. On my own, I've requested that they issue parole documents. I've told the clients to, when they have to do their check-ins, or go to ICE for the first time, like ask for parole just to see what will happen. But ICE usually, what they've told me in the past is we can't really override the paperwork that was issued to the respondent when they came into the country. So we have to deal with whatever that paperwork is and those facts. But people should still try to see if you can be successful in getting paroles issued by ICE. It's not guaranteed. So I want people to know that, especially practitioners, because they've asked me, well, can I just ask ICE for parole? I'm like, you can ask, but don't expect that you're going to get it, but you can ask. So
There's a lot of great questions. Um, and one question from Austin, Texas. We have started to see parole stamps on I-385 docs for very short periods, like 2 weeks or a couple of months. Is this a trend that you are also seeing?
Yes. Yeah, absolutely. That will suffice to adjust status, because the statute says if the person has been paroled in the past, so there was a parole. Um, I guess the only reason they're doing it for such a short time is so you can't get a work permit. So for a year, the person's not able to work and pay taxes. I don't know what benefit that gives to the government, but I guess it's the ability to give people a hard time.
Yeah, and I've seen those paroles too. If I, yeah, I've seen those, and ICE for some reason they don't believe that it constitutes a full parole. I'm not sure exactly what they mean by that, but that's what they've told me. Um, I think they said it was just a document issued to get the person out of detention, and so they gave them the parole. But you know, as we indicated during this presentation, that's fine. I mean, yes, it is a hardship for people to not be able to work if they can't get employment authorization while having to wait 1 year and 1 day. But unless they apply for asylum and you try to see if they have 180 days on clock or 150, depending on how they're applying, and try to be resourceful that way. But definitely, they will have an avenue of adjusting their status, even if it's for a very short period of time. That parole is valid, you know. So that's good.
If I can add to that, you said something very interesting there, right? It's only a document to release them from custody. That's what parole is. So
Mm-hmm.
there's an old Supreme Court case. It's Leng, Leng, May, Ma versus Barber. And the Supreme Court said exactly that. Parole is just a mechanism to release people from detention. That's all it is. It's not a fancy status. So for them to say it's not a full parole, that doesn't make sense. And it reminds me of stuff I used to see many years ago where you'd get the I-94 with the parole and they would stamp on there no EAD, no AOS, as if they can parole somebody but not allow them to apply for benefits for people who have been paroled. And USCIS has always disregarded that. So I'd be very surprised if USCIS is going to agree with that.
That's all the time we have. Thank you so much. And I'm sorry we couldn't get to all the wonderful questions. And I do ask all the attendees who want CLE credit to stay connected for instructions to get your CLE certificate. And also please wait for the evaluation to come up on your screen. And to our wonderful panelists for this program, Jasmine Coca and Mark Prada, thank you so much for sharing your expertise with us. And on behalf of the ABA, I'm Emily McCabe, thanking you all for joining us. And I will now turn it over to Osman, our operator, for some additional information.
Wonderful. Thank you very much, Emily. So thank you. And on behalf of the American Bar Association and the ABA Commission on Immigration, thank you for participating in this program. To learn more about the sponsors, visit the ABA website at www.americanbar.org. Thank you, and please click on the evaluation link. We value your feedback.